Now we're going to get down to the nitty-gritty of what Indians are all about.
I still say we Indian people are believers in the truth. This is the way of life that was given to your people. You're born an Indian, you're going to die an Indian. Indianness is a good life. You're facing an Indian this afternoon.
Good Saturday afternoon out there, everyone. Welcome to your number one source for Native American television news, Muskogee Vision. I am your host, Jason Salzman, and we've got a special episode for you today, and it deals with the Murphy versus Carpenter case at the Supreme Court. Oral arguments heard last week, and this Murphy versus Carpenter case, nationally getting headlines, will decide jurisdictional status of Muskogee Creek Nation going forward. If you've stayed with Muskogee Media for any amount of time, you know that we've extensively covered this case. Today, you are going to be able to hear for yourself oral arguments made at the Supreme Court last week. We'll hear from Deputy Solicitor from the Department of Justice, Mr. Edwin S. Needler. We'll also hear from, on behalf of Murphy and in turn MCN, Riaz Kanchi, and also, lastly, the counsel for Carpenter, Lisa Blatt, and that's all in the audio you are going to hear.
Mr. Needler, Mr. Chief Justice, and may it please the Court. What Congress did in the statutes at issue here is fundamentally different from what it did in the line of cases involving Solon. What Congress was doing here was transforming a territory to a state. And in order to do that, Congress broke up the national domain of the tribes. They had been independent nations, and it was a territory. The tribal domain was the territorial domain. Congress, as it always does in transforming a territory to a state, changed the territorial domain from here the tribes to the state, and then it vested the governmental authority over that domain in the state because that domain had become the state's, the general governmental authority. And it did that with respect to Indians and non-Indians alike, as the history that preceded it shows. Beginning in 1897, Congress extended the laws of Arkansas to everyone in the Indian Territory, irrespective of race, and gave the Indian territorial courts exclusive jurisdiction over all cases. The next year, it abolished tribal courts and said that their laws could not be enforced in the courts of the Indian Territory. And in 1904, immediately before statehood, Congress once again subjected Indians and non-Indians alike to incorporated state law. That is fundamentally inconsistent with the proposition that immediately after statehood, all of a sudden, Indians and non-Indians were to be treated differently in the new state. And in fact, we know that wasn't true because Congress provided in the Statehood Act for the transfer from the Indian territorial courts to the state courts of all crimes of a local nature.
Mr. Needler, what's so interesting about that transfer is that in 1906, the Enabling Act does say transfer, but in 1907, the Enabling Act amendment makes clear that the transfer is only of criminal cases. And your opponent says that, and if you read it, they're right, that federal question issues were supposed to remain in the federal courts. Now, they didn't. The functionaries transferred all criminal cases, even involving Indians on Indians, to the state courts. But how do we know what Congress intended except by its words?
Well, by
its words, it said all federal question cases, which include Major Crime Act cases, should stay in federal court. How do we read into what the functionaries did in the court systems into what Congress's intent was?
With all respect, I don't think it's fair to say functionaries. These were courts that transferred the cases.
Courts are not Congress.
No, I understand that, but these were courts that were contemporaneously interpreting the statute that Congress—
The problem is that Congress, when it did speak, basically said, we're not going to end tribal sovereignty. So the Congress exactly around this same time period, basically says we're not going to disenfranchise the tribes. We're going to keep them alive.
The question in this case is tribal authority, is actually federal and state authority over lands in which there is no tribal interest at all. We assume for present
purposes. Well, there was tribal interest. The lands were still allotted to Indians.
Yes, but once they were allotted, there is and passed out of Indian ownership, or at least passed out of restricted status, they were like all other lands in the state. And referring to the language that Justice Breyer quoted, he referred to tribal ordinances affecting tribal lands and the lands of individuals. Those are not the allotted lands that have passed out of tribal ownership. Today, there is less than 5% of the land in the Creek Nation is now restricted or trust property. The rest of it has all passed out of Indian ownership.
Yeah, Mr. Kneedler, could you
as Congress intended.
I'm sorry. Could you say something about the practical effects of the Tenth Circuit's decision on federal law enforcement and the federal judiciary in eastern Oklahoma?
Yes, it would be dramatic. It would transfer, and we assume this would apply to all of eastern Oklahoma, not just the Creek Nation. All of eastern Oklahoma, any crime involving an Indian as a victim or a perpetrator would be subject to federal jurisdiction, not state jurisdiction. And there are not the FBI resources, the U.S. Attorney resources, the other resources. It would also call into question a number of convictions that have been obtained under state law over the intervening years. And beyond law enforcement, under this Court's decisions in Sac and Fox and Chickasaw, the Indians could not be taxed by the state in the entire area of the former reservation of income tax if they earned it there. They couldn't be imposed a sales tax. This would be a dramatic change from the way everyone has understood it for the past 100 years.
And what would be the definition of an Indian for these purposes?
I think an Indian would be at least any tribal member. For criminal jurisdiction, you don't actually have to be a tribal member. Being eligible for tribal membership is sufficient. Something like 10%, I think, of the population of 1.8 million in this area, including the city of Tulsa, is in this area. And that would be – there's no reservation like that in the country. And after 110 years of everyone agreeing with this Court's decision in Hendricks, as we point out in our brief, shortly after statehood involved a special jurisdictional statute, but the underlying premise was that a case involving an Indian otherwise would have been transferred to the state. No one
All of those
questioned
things
that.
can be changed by Congress, can't they? Congress has the plenary power to give or take.
Well, with respect to retroactive effects on existing convictions, there would be a serious question as to whether – and that's no small matter. There could be several thousand convictions, as I understand it, in state court that might be called into question. But if I could go back and just explain why this is so different from the solemn line of cases. If you look beginning in 1893, Congress believed that it had to break up the national domain of these Indian nations in order to have a state. The two went hand in hand. So breaking up the national domain, which now includes a whole lot of...
it made breaking up the ownership of land.
No, but
it accomplished that with the allotment.
It was more than that, because the tribes in their treaties were given these as permanent homelands, which was both governmental and property. Congress believed it had to break up that national domain and the national sovereignty and transfer it to the state in order to have a state. And in the meantime,
but the
Congress...
The question is, Mr. Kneedler, did Congress in fact do that? Did Congress in fact decide that was essential to statehood, or did it do something less? Did it decide that it could make do with something that was short of the cession of lands that we've required in these cases? So if I could just go back to the question that I ended with Ms. Blatt on, I mean, it seems here Congress is very clear about we have two pathways and we'd prefer cession. And then the Dawes Commission comes back and says we'd prefer cession too, but we're not getting cession. We're only getting allotment. And that is exactly the distinction that our cases have deemed relevant when it's come to looking as to whether there's the kind of transfer of land that destroys a reservation.
If I may, there's nothing in the Dawes Act that said Congress preferred one over the other.
It says that there are two pathways, and then the Dawes Commission says it's really simpler to do session. We wish we could do session. We can't do session.
It's simpler, but that has nothing to do with jurisdictional authority. On page 79A, the Dawes Act, in relevant part, is set out. It's commanded the Commission, either by session or allotment, to do what it did to enable the ultimate creation of a state in the area. So
it's
Congress
agreed. They thought that you could get a state either way. Session was not necessary for a state. It was preferable for a state, but it wasn't necessary. And the Dawes Commission comes back and says we can't do session. We're going for allotment. They got their state anyway. What they did not do was to destroy the reservation in the way that Solem and all those cases that we've decided, and we've decided lots of them, have indicated is necessary to see before we say that a reservation doesn't exist anymore.
I respectfully disagree, because what they did was they broke up the nation, which was and allotted it to individual members. There were already at the time of statehood 700,000 non-Indians living in this area, and I think only maybe 70,000 Indians. It was overwhelmingly non-Indian at the time, and Congress had become very dissatisfied with tribal government over that area. That was the very reason that it prohibited the enforcement of tribal ordinances and gave all jurisdiction to the territorial courts. It's fundamentally inconsistent with that to think that upon statehood, Congress all of a sudden wanted to continue tribal sovereignty that did not exist. Congress had already taken away the governmental or sovereign part that is tied to session in those other statutes.
Before you sit down, you said very quickly the ramifications of the Court of Appeals decision in areas other than criminal jurisdiction. You mentioned tax, I think. Can you state again what is the effect of this decision on areas other than state versus federal jurisdiction?
Under this Court's cases, a tribal member cannot be taxed, for example, for sales tax, cigarette tax, gasoline tax, where the incidence is on the tribal member, anywhere within a reservation. And a tribal member cannot be assessed state income tax, at least where he resides and works on the reservation. And given the size of these territories, that could be quite a number of people. The liquor ordinance that was at issue in Parker requires tribal consent to the sale of liquor on a reservation. I imagine that would apply to any bar or any liquor establishment that may be in all of eastern Oklahoma. So, and again, 10% of the population is Indian. So the criminal jurisdiction concerns are really very serious. And the United States is very concerned about what would be a drastic shift in criminal jurisdiction.
Thank you, counsel. Mr. Gershengorn? Mr. Kanji?
Mr. Chief Justice, and may it please the Court, if I may, I would like to address three things. First, this issue of consequences. Second, to return to the question of governmental powers. And finally, to talk a little bit about contemporary understanding. With respect to consequences, there will not be turmoil from an affirmance. The Creek Nation wishes to be very clear that significant practical disruption would result from disestablishment, not from retention of the tribe's of the recognition of the reservation. It is true that Tulsa is not Pender, but Tulsa is not different from Tacoma, the city of Tacoma, much of which lies within the Puyallup Reservation, or from the millions of other acres of land which this Court said in Atkinson, non-Indian fee land, lie within reservation boundaries. There will not be turmoil because of three reasons. One, this Court's precedents restrict tribal power over non-Indians on fee lands within reservations. Those are restraints that we understand and respect. Secondly, and conversely, the state retains plenary authority over non-Indian fee lands within reservation, plenary authority to tax and to regulate. And third, and Oklahoma, the history of Oklahoma is not exceptional, but what is exceptional in Oklahoma is the extent to which the state and the nations have forged cooperative agreements that already address many of these issues.
Well, suppose an Indian is charged with having committed a mugging in Tulsa, where will that case end up?
If an Indian, Your Honor?
Yeah.
That case would end up either being prosecuted by the federal government or by the nation itself, or both concurrently.
Okay. And how many cases like that do you think there may be?
Well, as Mr. Gershengorn said, we have these estimates from the federal government, which I think were clearly inflated. There may be 100, 200 a year, that sort of thing. It's
really,
important to
they're only within what percentage of the population of this area would qualify as Indians?
Of the entire reservation area, about 9%, Your Honor.
9% of how many people?
9% of about the Creek population is 43,000.
Yeah, but all the Indians, so this would apply as far as criminal cases to all Indians. Am I right?
That's correct, Your Honor.
Yeah, and how many would that be?
Well, we don't have exact numbers, but 50 to 60,000 Indians within the reservation area.
So if any of those individuals was charged with any offense that would normally be prosecuted in state court, they would all have to be prosecuted in federal court.
Or by the nation. And I think it's important to reinforce that the nation has a robust criminal jurisdiction, has robust courts, is already prosecuting many Indians. The nation also supplies a special U.S. attorney to the United States to prosecute major crimes as pursuant to congressional authorization. It's critical to understand nobody has a greater interest in law enforcement and security within the Creek Reservation.
It isn't just that. You said something about cooperative nature, and most of the laws that have been passed by the Creeks, which were mentioned by Mr. Gershengorn, were passed pursuant to much later statutes passed by Congress. And how is there anything we can do to encourage, require what? To have the Creek Nation, the state, and Congress work this out to see if there are difficulties, and if so, resolve them by statute or regulation. You see, you're asking me something I don't know. I don't know how much trouble this causes, and the reason there's a picture of Tulsa in the brief, I thought, was to stimulate me to ask such a question.
Exactly. Your Honor, I think that the simplest answer is that an affirmance will stimulate exactly that kind of discussion and agreement. The last time this Court had a case from Oklahoma involving jurisdiction was the Chickasaw Nation case in 1995. This Court ruled in favor of the Chickasaw Nation. Shortly thereafter, fuel tax agreements were forged in the wake of that. The same will happen here. There already are discussions taking place here about the allocation of jurisdiction. Congress has provided mechanisms for the allocation of both criminal and civil jurisdiction.
You're talking about discussions between Congress, the state, and the nations?
Correct, Your Honor.
And you think that'll lead fairly quickly to an agreement that will settle all these disputes?
I think all sovereigns have an interest, a very common shared interest, Your Honor, in law enforcement. The brief of the Oklahoma officials, I think, evidences that there is a very close working relationship, in fact, on the ground between the state, the local units of government, and the nation. That will continue.
Can there be such a thing as a reservation that exists as an abstract matter, but in this territory the nation is able to exercise no sovereign powers as a practical matter? Is that a possibility?
It is, Your Honor. A reservation, as Justice Kagan said, when Congress takes any block of land, reserves it from the public domain, reserves it from sale, that creates the reservation. Then in order for that to be returned to the public domain or to be disestablished, Congress has to expressly indicate that intent. There have been not just with, and I think this is a critical point that Justice Kagan suggested to, there have been reservations around the country over time where Congress has abrogated tribal powers.
So if we don't agree with you on that point, if we think this is a practical inquiry, could you tell me what sovereign powers the nation retained within this territory after statehood?
Absolutely, Your Honor. It retained legislative powers. I think the 1909 Congressional Act that we cite at page 24 of our brief is instructive. There, Congress was attempting to equalize allotments on the reservation. It made its efforts contingent upon approval by the Creek National Legislature. the national legislature refused to give that consent. So not only Congress recognized that the legislature remained in force, but the legislature had the authority to say no to Congress.
Could tribal laws be enforced at that time, after statehood?
Yes, Your Honor. Just as before statehood, they were being enforced by the Secretary. And I think a critical point is this Court in Morris v. Hitchcock and the Eighth Circuit in Buster, immediately before statehood, affirmed the nation's continuing legislative authority, including with respect to non-Indians, and said that the secretarial enforcement mechanism was the mechanism to enforce the continuing legislative jurisdiction.
Could you say a little bit more, Mr. Kanji, though, about the converse proposition that there indeed have been reservations that everybody has understood to be reservations historically throughout the country where tribal governments exercised precious little authority?
Absolutely, Your Honor, and I'll give you a general and a specific example. Generally speaking, Congress has told the tribes over time, your government will be structured in this fashion. Your membership will consist of the following. You will allow this mining and these easements on your land even if you don't want it. You will allow your children to be taken away and placed in boarding schools even if no parent would want that. Even this, the rhetoric about buildings being sold, the Creek Nation is not the only tribe in this country, far from the only one, to have run its government out of churches and house basements for decades. A specific example is the Metlakatla Reservation in Alaska, the only Indian reservation in Alaska, as this Court said in the Venati decision. This Court's decision in Egan from 1962 indicates the draconian restrictions that government was laboring under. It had no authority to approve anything without the approval of the local education commissioner. And yet that was still understood and is still recognized as an intact Indian reservation. Justice Breyer talked about the approval of ordinances by the president. I think it's instructive. Today, the Creek Nation does not have a presidential or secretarial approval requirement, but many tribes in this country do, including the Omaha tribe that was the subject of Parker, the Cheyenne River tribe that was the subject of Solomon. In both of their constitutions, there is a requirement that the United States inserted that the secretary has to approve largely any and all of their ordinances.
Counsel, would this expand the reach of the Indian Gaming Act in the area?
It would not, Your Honor, in the sense that there is a compact in place between the nation and the state already. The nation has 8 gaming operations within the area.
What about the Oneida tribe idea of laches or something like that?
Well, I think that was a critical point in Parker, Your Honor. In Parker, this Court declined to reach the diminishment decision and said, we will apply this laches doctrine to this particular exercise of power by the Oneida tribe. Here, we don't even have an assertion of power by the Creek Nation. The Creek Nation had nothing to do with the genesis of this litigation. If in future cases we were to assert our authority in a way that others found objectionable, they could raise a Sherrill claim, and that could be adjudicated at the time. But the important thing is reservation disestablishment is a binary thing. The state is asking you to snuff out all Creek governmental powers over this area. As we document in our brief, the Creeks are doing many things that pose no affront to the justifiable expectations of anybody, but that in fact serve the expectations of all but hardened criminals. The Creek Lighthouse Force polices the entire reservation pursuant to these cross-deputization agreements. The Creeks are providing health care, education, infrastructure, and this is all vital, and a disestablishment would snuff all that out.
Thank you, Counsel.
Chief, may I just ask one question to follow on that?
Sure.
Your colleague also said the same thing, but when you say they've been policing and doing these things in the reservation, are you talking about the entire area in dispute right now?
Absolutely, Your Honor. There are 44 county and municipal jurisdictions in the Creek Nation Reservation. The nation has cross-deputization agreements with 40 of them, so almost the entire area.
And for how long has this been in effect?
Those agreements first started in the year 2000, Your Honor, and a critical point I'd like to make in terms of disruption is they are all subject to renewal each and every year.
And in 1936, the tribal courts were reignited.
That's
tribal
right.
Courts. And what area did those tribal courts exist in?
They likewise exercise jurisdiction over the
entire reservation.
That's correct, Your Honor.
Thank you, counsel. 2 minutes, Ms. Blatt.
Thank you, Mr. Chief Justice. Here are the two earth-shattering consequences that Congress can't fix, Cheryl can't fix, and this will stimulate you. There are 2,000 prisoners in state court who committed a crime in the former Indian Territory who self-identify as Native American. This number is grossly under-inclusive because if the victim was Native American, the state court also lacked jurisdiction. That's 155 murderers, 113 rapists, and over 200 felons who committed crimes against children. Here's why habeas is not going to help. As footnote 5 in the Tenth Circuit's decision says, there are no apparent procedural bars in state court to lack of subject matter jurisdiction. The reopening of any of these cases would re-traumatize the victims, the families, and the communities. Nor is it clear that the federal government could retry any of these cases because the evidence is too stale or the statute of limitations has expired, which appears to be the case in about half of them. Here's the earth-shattering consequence on the civil side. Under the Indian Child Welfare Act, any tribe, any parent, and any child can undo any prior Indian child welfare custody proceeding if the state court lacked jurisdiction because the Indian child lived on a reservation. Affirmance raises the specter of tearing families all across eastern Oklahoma and probably beyond for years and years and years and years after the fact. ICWA also means, and I don't see the tribe agreeing not to enforce ICWA, ICWA also means that any Indian child welfare proceeding must be brought exclusively in tribal court, even over the parent's objection. That's on the consequences. On the tribal sovereignty, with all due respect, I didn't hear an answer. The most that they said was they dispersed tribal funds. That is not sovereignty over non-Indian-owned fee land. Thank you.
Well, thank you. Ms. Black, since there was an extension for the time on the other side, could I ask this question? There seems to be a disagreement between the attorneys here about the authority of the nation to enact and enforce laws after statehood. Could you just briefly address that?
I mean, that's preposterous to the extent that it affected non-Indian-owned fee land, non-tribal members, or tribal members. Every tribal chief that we cited, every federal court, every tribal lawyer, members of Congress, every Oklahoma historian, and the popular press recognized, and some of these are not racist, but they are the foremost Indian scholars of the time of Oklahoma, that the tribal governments had ceased to function. Thank you.
Thank you, counsel. The case is submitted.
And there you have it. That is excerpt audio out of the full audio version of last week's Supreme Court oral arguments in this case. Now, if you want to hear the full audio that hasn't been cut for time, you can do that on our YouTube channel. It is available. So just go to youtube.com, search for Muskogee Vision, search for Muskogee Media. Either one will take you to our page, and you can see the full audio excerpt from last week's Supreme Court hearing. It's all there. So we want to thank you today for joining us on this episode. Stay with this case with MuskogeeMedia.com. Muskogee Creek Nation making national news. So it's something that we've really been able to cover for quite a while here. And, we're reaching here sort of the end of this, and we'll have a decision come up soon. But oral arguments have been made at the Supreme Court. We want to thank you for joining us as we always do every week. You all have a great one. We'll see you next time, same place, same day, right here on Muskogee Vision.